Good afternoon, ladies and gentlemen. It's a great pleasure to give this lecture about the topic of sports and IP for this class of May 13. Knowing that we'll get to discuss the case studies that we've invited you to look at the beginning of next class, next week on May 20th. So sports and IP is a quite important topic in practice because the sports industry is what could be qualified as a quite IP intensive industries. And what I mean by this is that the sports industry relies quite extensively on IP rights and quite importantly on all the different types of IP rights. So be that trademark, copyrights, also patents to a certain extent, and also design. So that means it's an industry which needs IP and actually needs IP also in order to be financially sustainable. Without IP rights, the IP ecosystem would be strongly affected and impacted in a way that would also potentially threaten the possibility to fund the organization of sports event and also of sports championship. And another interesting feature of the sports industry is that it is challenging the IP legal system because there are challenges arising in the sports industry which don't necessarily happen in the same way in other industry. If you look at, as reflected on the screen, the challenge of fighting against online piracy of sports event is something which is quite unique to the sports industry because, as we all know, everyone is motivated and willing to watch a soccer game or another sports event live, but then the interest to watch it subsequently really significantly drops. So that means there's an increased need to protect against the online piracy of sports events, which calls for specific remedies. Now, another interesting introductory comment which must be made is to realize that we are also at the heart of the international sports ecosystem. We've been talking, this is what we have at the bottom of the screen. We know that in Geneva, we're very privileged because we host the two key players in terms of IP policy making, WIPO and the World Trade Organization, but what is perhaps less established and well known is that we are close by, not necessarily here in Geneva, but in the Lake Geneva region. We host all major key players in the sports ecosystem, starting with the International Olympic Committee, and that is something which also must be noted from the outset. Now, the importance of IP for the sports industry, and I mentioned that in the class last week, is also reflected in the topic that was selected by WIPO itself for the World IP Day, which took place on the 26th of April. And I invite you to look at the very well structured and informative website that you have on the screen, including videos, which here confirms the key importance of sports, of IP in the sports industry. And you have various documents on the relevant website which is on the screen, including this reference guide to sustaining sport and its development through IP rights that I had the privilege to author for WIPO, and which is also available on the dedicated webpage they have on the screen. Now, today, for today's lecture, what I wanted to focus on is to address the two topics that are on the screen, starting from the top of the sports ecosystem and the sports pyramid, as we sometimes call it. It's to talk about the Olympic properties as protected also by sports regulation and the Olympic Charter, and we'll get to discuss that in a second. And then turning to one area of IP, which is of specific significance and importance in the sports industry, which is trademark law and unfair competition law, and specifically the fight against so-called ambush marketing activities, to which we'll turn subsequently. So As to the Olympic properties, we're looking at the Olympic Charter, which is basically the constitution, so the highest ranking legal document at the very top of the Olympic ecosystem, which protects a broad range, as you can see, of intangible assets, including and starting with the Olympic symbol, and we'll get to discuss the Olympic symbol in a moment also because it's protected by an international treaty, Nairobi Treaty, to which we'll turn in a second. But you see, there is a broad scope of protection and categories of IP rights, including looking at musical works, but also the motto, the anthem, and other types of work. And importantly, as you will have noted, these are referred to as property. So that is obviously an allusion and a reference to the fact that these intangible goods are supposed to be owned by, and this is what we see also on that page, they are supposed to be owned by someone, and more specifically by the IOC, and that there's some kind of property right which is conferred upon them, which makes it possible for the IOC, and this is result from the last sentence that you have on the screen, to license out all these rights on contractual basis as reflected by the IOC Executive Board, which is the highest governmental body within the IOC ecosystem. So that's for this Olympic Charter, which importantly is not directly binding. It's not an international treaty in the classical sense, so it's not binding on anyone, on any country as such. It's all simply part of the sports ecosystem, meaning that those within the Olympic pyramid, so to say, including, for instance, athletes taking part to Olympic Games, or trainers taking part to Olympic Games, or other stakeholders in the IP ecosystem, Olympic ecosystem, they're supposed and they have to abide by the Olympic Charter. Now, moving away from the sports regulation and specifically the Olympic Charter, we can also look and should look at classical international treaties. And this is the Nairobi Treaty to which I was referring earlier, which interestingly is managed by WIPO, as you can see, which has now 50 plus countries as signatories, which are bound by the treaty. And in the treaty, you will see that there is a protection which is granted to the Olympic symbol, which is the symbol that you see on the screen, that, and you know perfectly well, each of these circles representing one continent, and as I'm sure you know, and in the provision of the treaty, they also refer there's some kind of exclusivity, I'm sorry, and control over the use of the Olympic symbol, specifically for commercial purpose, which make it possible, as you can read, to refuse or to invalidate the registration of trademark and to prohibit the use of such Olympic symbol in the countries which are covered by the Nairobi Treaty, unless, of course, this is authorized by the IOC, and this can be done, and that somehow reflects what we've just seen in the Olympic Charter for the benefit of official sponsors of the Olympic Games and the Olympic movement. And you see this is a definition in the appendix, in the annex of the Nairobi Treaty, which defines what we talk about when we refer to the Olympic symbol. Now, interestingly, the Olympic properties have been the target of many campaigns by which third parties unaffiliated with the Olympic movement have tried to benefit from the fame and positive image and reputation of the Olympic properties. And this is a quite well-known case coming from France, where a supermarket chain, Edouard Leclerc, had launched an advertising campaign promoting the so-called Olymprix playing with the words in the French language, and used the caddie as the so-called official transport of the Grand Prix by making at least indirect reference to the Olympic Games. And the question was whether this would be constitute a trademark infringement under French law or another illegal activity. And ultimately, after a long court battle, the highest French judicial body, the French Cour de Cassation, decided that Edouard Leclerc had committed indeed an act of unfair competition by taking advantages, as you can see, an unfair advantage, free riding in a way over the official IOC movement. And this is already kind of a sign of what we will discuss when we talk, an example of what we'll discuss later in terms of ambush marketing. Now, interestingly, that was before French law had adopted a specific provision. You see on the screen a specific provision which was recently adopted, which grants some control, as you can see, to the French National Olympic and Sports Committee, including on the Olympic symbol and the designation Olympic Games and Olympiad, which then in the second paragraph that you're on the screen makes it possible to prevent basically the unauthorized use of those symbols. So you see local implementation of the protection of the Olympic properties. That's for France. Now, an interesting case, but this was decided some years ago in the US, was about the launch of these gay Olympic Games. You see the logo and the graphical representation at the top right of your screen. And in that case, the US Supreme Court, interestingly, confirmed that there was a specific protection granted to the Olympic term, which, as you can read, didn't require a showing of a risk of confusion. So that means from a trademark law perspective, we usually require a risk of confusion, but here there was a specific protection, which was actually broader, granted to the use of Olympic term. And interestingly, that's last bullet point on the screen, there was no way for the organizer of these gay Olympic Games to rely on free speech arguments to prevent the protection of the Olympic term. This was not a valid defense. So the takeaway from this case is like broad protection, specific protection granted to the term, to the Olympic terms under US law. Now, turning to the second facet of the discussion for this course about trademark law and fair competition. And what I want to do is just to look at the three facets of trademark protection that you have on the screen, looking first as to the conditions of trademark protection. So what do you need to have in order to benefit from trademark protection? And we look at specific situations which are of relevance in the sports industry. Then turning to question number two. So assume that you have a trademark which is protected. What is the scope of protection of that trademark, and against what type of activities can you act as trademark owner? And the third and final part is kind of a move away and transition from trademark protection to ambush marketing. So in certain circumstances, a third party will not mention the trademark of the organizer of sports events, and specifically Olympic Games, but they will still potentially refer to the Olympic Games somehow in the way that we just discussed with the Edouard Leclerc example from France, where they would somehow allude to the event, and that can constitute potentially an act of unfair competition, of ambush marketing, as we'll get to discuss later on. Now, as to the condition of trademark protection, you have on the screen an excerpt from the TRIPS agreement, which defines what can constitute a valid trademark. So it's a sign, basically, be the graphical representation, a logo, also a word or several words. And if you have a valid trademark, then you get a property right, which is the very point of applying for trademark protection. Now, in terms of general principle of trademark law, There's an obligation. We know that also from what we've analyzed previously in the case, that the basic rule is that you need to apply and obtain registration with the priority in terms of timing. So first to file applies with respect to trademarks as well as with respect to other industrial property rights, unless you can rely on well-known trademarks as a matter of principle. And this is what we learned specifically, as you will remember, in the Triplet case. And the other important facet of trademark protection is that you benefit protection only for the classes of goods and services that you have identified in your trademark application, subject to a specific quite established trademark, the so-called famous trademark, which may benefit from a broader scope of protection. Now, what examples do we have of trademarks which have been filed for in the sports industry? You have mascots. This is the mascot, as you may perhaps remember, from the Paris 2024 games, with all the relevant specificities relating to the trademark, including the goods and services for which, so according to the so-called NIS classifications, quite diverse. And if you go and check the excerpt of the registration, you will see that many goods and services have been applied for. This is EU trademark. You can also obviously file for trademark, and this is what was done for other mascots, for other events. But quite importantly, it's also relevant to note that not only sports organization and league institutions can file for trademark protection, and we see that quite a lot, but also athletes can benefit from trademark protection. If you look at our national sports icon, Roger Federer, if you look back at history, you'll see that the brand somehow has evolved over time, and including the signature and former logo. And interestingly, and also a quick side note on the RF trademark that you have on the screen, as some of you, those of you who are sports fans and Roger Federer fans, perhaps they may remember that there was a debate at the time when Roger Federer somehow left Nike to go to Uniqlo as a brand ambassador. There was a question as to who owned the RF trademark that you have on the screen, and it appeared that the trademark was actually registered not by Roger Federer himself or by his companies, but was registered by Nike. So there was a debate at that time, and that made also the headline, because the move from Nike to Uniqlo also provoked a drop in the Nike share price. This is what was mentioned on the screen. But importantly, also in terms of trademark protection, there was a debate as to whether Roger Federer could get back those trademark representing his initials, which ultimately happened. And this is what was achieved ultimately, probably on the basis of an agreement between Nike and Federer. And if you go and check the trademark registry, you will see that the RF trademark are now owned by Roger Federer or by an affiliated company. Now you see that happening also for other athletes, as I was mentioning, Bale, the English soccer player who used to or still does, I'm not sure, makes that sign of a heart, has filed for trademark protection. This is a UK trademark with the number 11 in the center, showing that trademark law is also used increasingly by well-established athletes to protect their brand in the broadest sense. Now, beyond these examples, one interesting facet of the discussion about the use of trademark in the sports industry is to talk about these sports-related trademarks. And one challenge of trademark registration in the sports industry is about the registrability of descriptive trademark. And the relevant provision at the international level is the one that you're on the screen, Article 15 of the TRIPS agreement, where basically the statement is made and the rule is expressed that if you have a trademark which is not sufficiently distinctive, then in the first place, you may get that distinctivity and distinctiveness by using the trademark on an intensive basis. And this question arose in the context of the registration of certain of the trademarks that you see at the bottom of the screen, Germany 2006, World Cup in the Swiss, and the comment and the critical let's say, situation resulting from the fact that those trademarks are descriptive. So Germany 2006 is simply a way to refer to what did happen or should happen or would happen in a given country, Germany, in a given year. So the point was to say, well, you cannot monopolize these terms, which should ultimately remain the public domain for everyone to be used. And for that reason, this specificity of sports law and major sports event has led to some specific provisions being developed. And you have on the screen the so-called trademark guidelines. So it's not a binding document, but still a quite relevant documents with respect to the registration of EU trademarks established by the EUAPO, where basically they focus on this format of trademark, which is exactly the one that I was just alluding to. So Germany 2006, so city plus name or country plus name, which, and you can see the reference here made to that case that I was mentioning earlier, Germany 2006, which was to consider to be as a descriptive indication. So that means no possibility to register it as a matter of principle, unless, and that's the point, unless the trademark would have acquired a so-called secondary meaning. So it would have become distinctive through the use, so that the audience and the public would be in a position to recognize that the trademark referred and does refer to a specific event and is thus not descriptive anymore. And this is what was made for Swiss trademark for Euro 2008, when the Euro was organized here in Switzerland, also in Australia back in 2008, because it was so well established that when people were thinking and seeing this Euro 2008 trademark, they didn't think about any event taking place in Switzerland relating to Euro in 2008, but they had in mind the soccer tournament from that perspective. And one issue here, I'm not going to read aloud either what you have on the screen, which has a significant importance in the sports industry, is about the length of use. Because as a matter of principle, and this results from what you have on the screen, if you want to establish that you have acquired distinctiveness, so the sign is not intrinsically distinctive, but it has acquired distinctiveness because of the use. Usually it takes quite some time to establish this. And then they have somehow come up with a specific situation for sports events, because, for instance, for Paris 2024, as soon as the decision was made that Paris would be the city organizing the event, it was well known almost immediately at the global level. So there is no need to wait months or even longer to establish the acquired distinctiveness of those trademarks. And that means there's some specificity in trademark protection for this so-called city plus year or country plus year trademarks. Now, we have in Switzerland a quite interesting case, which was decided relatively recently by the Swiss Federal Court. You have the full reference on the screen, which was a dispute between Puma and FIFA. And the key point is that Puma was not an official sponsor of the Qatar 2022 World Cup, but still did register. As you can see, these are the two trademarks on the left-hand side of the screen, which combine the brand Puma with World Cup Qatar 2022. And in that context, as you can read, the Swiss Federal Court decided that the Puma trademark were deceptive. So they're creating wrongly the impression that Puma was an official sponsor of the World Cup. And turning to the FIFA trademarks that you have on the screen, the Swiss Federal Supreme Court decided that the two trademarks, Qatar 22 and World Cup 2022, were not protectable either because they were descriptive. So you could see everyone lost basically, both Puma and FIFA lost in this case, which shows here again the complexity that can arise when registering trademarks which are connected to the organization of a major sport event. Now, turning to the second issue, which is scope of trademark protection, interestingly, this is something that is also of relevance, which is Article 16 of the TRIPS agreement, which defines the scope of protection of trademarks. So that means that the infringing party must use in a commercial context, so in the course of trade, and the use must relate to identical or similar signs. So the trademark must be identical or similar, and also in terms of the connection to the goods and services. So the goods and services should also be identical or similar to those in respect of which the trademark has been registered. And this is an application of this principle of specialty that we discussed earlier. And ultimately, as you can read, that should lead to a risk of confusion. So there's no need to show a real confusion, but likelihood of confusion is sufficient. So there are different examples that have arisen in the sports industry, one of which this is taken from a decision of the IP office rendered some years ago, where the first trademark which was filed, which had priority, was the EU 2008 trademark on the left-hand side. And the question was whether the trademark on the right-hand side, Euro 08, was and could be considered to violate the pre-existing trademark. And the answer in that case, that it was indeed the case. Also on the grounds that if you pronounce orally the trademark on the right, that would lead to Euro 08, which obviously is quite similar from that perspective to the trademark on the left-hand side. So that shows that there was a reference, an allusion somehow, which was certainly in the mind of those filing for the trademark on the right-hand side, and led to a finding of infringement of the pre-existing trademark. So that's one scenario. Another interesting and quite well-known case of where the issue of trademark infringement arose was about Mr. Matthew Reed, and you see him at the bottom right of the screen. At that time, he was still smiling, and he was probably not smiling anymore when he got the final decision from the Court of Justice, to which I'll turn in a second. What was Mr. Reed doing? He was basically commercializing non-official T-shirts and other merchandising products of the Arsenal team. And what he did, which was interesting, is that he included some kind of a disclaimer on those products, by which basically he was saying that these are not official products and they should not be confused with the official Arsenal merchandising tag, which are official products. And now the question which arose and went up to the Court of Justice of the EU was whether the use which was made of those Arsenal trademark constituted trademark infringement, whether that was something which was done in the course of trade. Remember, this is what we could see in Article 16 of the TRIPS agreement, or whether that's something which was done purely for descriptive purpose. And fortunately, I would say, the Court of Justice decided in that decision that it rendered some years ago that this was indeed an illicit use of the trademark, because ultimately the trademark was identical and the goods were identical too. And there was no way for Mr. Reed to somehow avoid liability and avoid the infringement of trademark by claiming that this is something which is done as if I quote what is at the bottom of the screen, as a badge of support for as a loyalty or affiliation to the trademark operator. So there was no valid defense. So a finding of trademark infringement in this circumstance. Now, what about the limits of trademark protection? And we're now moving from trademark law to unfair competition and perhaps specific regulations like ambush marketing. And this is also connected to the example that we shared with you that we'll discuss next week. So many examples of ambush marketing activities, including the one on the screen, were back in 2010 at the FIFA World Cup in South Africa. The official partner and sponsor for beer was Budweiser. But an event was organized by a competing brand that you have on the screen, which somehow materialized in the presence of a group of ladies, all dressed in orange, basically promoting the competing brand within the stadium, and which attracted a lot of attention and somehow led actually to their expulsion from the stadium and led also to potential other consequences. But the point is, what about these activities where there's obviously no misuse of the trademark as such, so no reference to Budweiser, no reference otherwise to other protected trademarks, but still a behavior that somehow affects the business model and the exclusivity of sponsors, of the organizers over the control. And you have watched that video in the Nike campaign where basically they did some kind of a world tour of all the cities called London outside of the UK, and did not make any explicit reference to the Olympic Games, but still somehow alluded to them with a question which is of relevance to us. Is this sufficient to create a legal violation, in this case not a trademark violation, but more a violation of unfair competition? And we have to discuss that now more precisely. Now, what can you do against these ambush marketing activities where you basically try to take advantage of the fame and reputation of a famous sports event, specifically the Olympic Games, without, of course, paying the price for it, because only the official sponsors pay the price? And is this something that calls for specific regulation, or can that already be addressed by relying on general provision against unfair competition? And which raises the question of what is the general law against unfair competition? And we go back to a provision that we've just discussed, but in another context, which was trade secret. As you remember, 39 paragraph 1 of the TRIPS agreement about the protection of undisclosed information does refer to 10 bis of the Paris Convention that you have on the screen. And you have the different activities in paragraph 3 of 10 bis, as we have actually discussed previously in the course of our trade secret, enumerates in a non-exhaustive manner a few activities which can amount to unfair competition, including, as you can read, creating confusion or misleading the public. And the question is that sufficient to potentially block infringing activities and unfair competition activities, and more specifically ambush marketing activities? So that's one approach, relying on general unfair competition law. But another approach, which has been adopted and to which we'll turn now, is to look at specific regulations which have been adopted in order to avoid this type of ambush marketing activities. And this is what was done, among other examples, for the 2012 London Olympic Games, where they have created this so-called London Olympics Association right, that is interesting to look at now. So what is this London Olympics Association rights? So they have created, on that basis of the specific regulation, a specific right, the right of association, which somehow makes it possible to create exclusivity. You see, exclusive rights, kind of property right in a way, to control those trying to create the suggestion to the public, looking at what you have on the screen, that there would be an association between the Olympic Games and certain goods and services and those persons of providing goods and services. And quite importantly, looking at the definition of the concept of association, that shall include, as I'm looking at Roman 4 here, the provision by a person of financial and other support for in connection with the London Olympics. And what is meant by this is that we don't want anyone, and that's one facet of the discussion when we talk about ambush marketing, is to avoid the non-sponsor who pay nothing to be sponsored of the Olympic Games here in London, that those non-sponsor can create the wrong impression that they would be connected to the London Olympic Games. So we basically want to create that exclusivity to avoid that third party can, again, free ride. Remember the terminology that we've seen when talking about the Olymprix Edouard Leclerc case. This is the type of idea that is at the core of the protection against ambush marketing. And quite interestingly, in the same regulatory source, there is also kind of a negative definition of this right of association, saying that there is no creation of an association if the statement is made by someone accords with honest practices in industrial or commercial matters. Now, this should ring a bell because, as you know, and as we've just seen, this is the wording which comes directly from Article 10 bis of the Paris Convention. Remember, we have seen that a variation of this terminology and formulation in Article 39, paragraph 2 of the TRIPS agreement. And you see that appearing again in another context, which is the fight against ambush marketing. So if you use and you make a statement which is also quite importantly not made in a commercial setting, for instance, for journalists referring to the games, otherwise they should not be a violation of this right of association. And interestingly, in the documents that the organizer of big events and specific Olympic Games publish in order to kind of instruct and inform the public and third parties about the scope of their rights, they have come up with this fictional example that's on the screen with the question whether this would amount to a violation of this so-called London Olympics Association right. And I think in this case, and this was also the way how that was presented in this kind of information materials, this was clearly a case of violation because even though, quite importantly, as you will see, there is no direct reference and no use of the term Olympic, and this is a fictional advertising campaign for that company called Gascorp, which uses the slogan "Lighting the Flame." But of course, if you look at the Olympic torch, at the slogan, at the background representing London, but also quite importantly at the phone number 2012, which is the year of the Olympic Games, you have the impression that this company somehow creates an association for commercial purpose because it's an advertising campaign, and that should be prohibited on the basis of this London Olympics Association right. So you see that also being done for every edition of the Olympic Games. This is taken, as you can see, for the Tokyo 2020, actually 2021 games, where basically they consider that the use of those terms can be deemed as ambush marketing. So if you use the slogan London, Rio, and Tokyo, obviously people will have in mind the different places in which the games have been organized, and then that should be something that should be prohibited. The same source on this document, instruction document, also mentioned the example there on the screen, which are all considered to be violating the rules against ambush marketing, reference to this mug for a fictional ABC cafe, referring to the year and to the games. Same here, kind of somehow stylized version of the Olympic symbol. And here again, some for this fictional ABCD company, a reference to the Olympic Plaza, to the location of the games. So just to say this is something that is important to observe. Now, another important recent facet, or more recent facet of ambush marketing is connected to situation in which athletes somehow do somehow play a role in promoting brands which are not official sponsor of the game. And this is what happened. That was also at the London Games, where basically this headphones were used under the brand of a company which was not partner of the Olympic Games in London, were basically used by athletes. And this is well represented on the cartoon that you're on the screen, where basically you have, as you can see, the official sponsor in the background, but actually the attention is attracted to the headphones that are worn by athletes. Obviously, the athletes in any sports events drive the attention and deserve the attention of the audience. So if you have in the background, in a less visible manner, the official sponsor, but something which is more impactful, which comes from a non-official sponsor, this is something which might be a problem from a ambush marketing perspective. Now, you see that happening in various ways, including, just by way of illustration, what was done by this soccer player, which got like heavily sanctioned, as you can see, for improper conduct. The improper conduct was not because he was half naked, but because he was showing the brand of a company which was not a sponsor of the relevant event at that time. So this is something that also is interesting to observe. Now, coming back and focusing on the Olympic system, this is something which was regulated in previously in the so-called bylaw to Rule 40. So Rule 40 is one of the rules contained in the Olympic Charter. Remember, we've seen another rule, Rule 7, about the Olympic properties. And the point was to say that in order to protect the Olympic system, but also to protect the official sponsor, the competitors of the athletes participating to Olympic Games shall not have the possibility, as you can see on the right, to allow their person name and pictures to be used for advertising purpose during the Olympic Games. And that was meant that the individual sponsors, non-Olympic sponsors of those athletes could not basically promote and advertise the participation of those athletes during the Games. So this was quite restrictive for athletes and also had a significant financial impact on the athletes. That means they could generate less revenue because their personal sponsor would have no right to do some communication during the Games. So that led to some kind of reaction and criticism among Olympians, so athletes taking part in the Games, as reflected on the screen, which led also to litigation in Germany from a competition perspective, antitrust perspective, and to the adoption of a new rule that was adopted a few years ago, 2019, as you can see, which somehow, if you compare the previous version and the new version, you will see that the system has totally changed. So now, instead of being prohibited, now the rule is that it's possible for athletes to communicate, but this must be done in line with certain principles which are set by the IOC Executive Committee. And this is what has been done for each and every edition of the Olympic Games. You have on the screen, and you look on the website, you will see the more recent version for the recent Cortina Milano Games. This is a document which was established by the International Olympic Committee, which defines the boundaries of what can be used and what can be done in terms of advertising by athletes in the game, and also by non-official and non-Olympic sponsors of those athletes. And they have come up with a few illustrations. Remember, this is what we've seen with this torch image for the London Games, also for the Tokyo ambush marketing cases, and they've done so also to make it understandable for non-experts and specifically for athletes and for the sponsor, they have come up with specific examples, including the one that are on the screen, where in essence you see that the only advertising campaign which was held valid is the one at the top left of the screen. Why is that? Because here, so the fictional X brand with a neutral slogan, bring out the power, where also they describe obviously the track record, so to say, of this fictional athlete. And now if we turn to the other example, we see that this is considered as not being admissible because there is a reference to the game, Road to Paris. And here, quite importantly too, even though the slogan is neutral, bring out the power, and let's say the track record remain the same, the difference is that, as you will have noted, there are two obviously quite well-established monuments in the background which do refer to Paris, and that is held as sufficient to trigger the application of ambush marking activity. So that means that athletes must also pay quite a lot of attention and do comply with ambush marketing regulation, because if they don't comply, and that's the final word on this, if they don't comply, they might be potentially subject to sanctions because they're part of the Olympic movement, and so they're supposed to comply with Olympic regulations, and one of the Olympic regulations results from this so-called Rule 40 regulation, which is exactly what we're discussing here. And with this, I shall stop and we'll get to discuss the two case studies about sports on IP when we meet again in person for the next class. Thank you for your attention.